All right. Well, we will go ahead and come to order. It's good to see you. Want to thank everyone for being here this morning, and we'll begin as we always do with a prayer. If you'd like to join me, dear Heavenly Father, we thank you for this opportunity to work on the issues important to the people of Georgia, and we ask for your special blessing and looking after those victims in Ukraine right now, and we ask you to put your guiding hand over those who are undergoing what's taking place there, and that you can show your glory and mercy for all those victims involved. Amen. Want to go ahead and tell everyone here today that we have two bills on the calendar that are, I'm not sure if it was noticed when we put out the agenda, but they're just on for a hearing only today. The objective today is to hear from witnesses who have important testimony to give the members of the Judiciary Non-Civil Committee, and to do it in a setting where we can really hear any input that that needs to be provided for these two important bills. And so what I'll do is I'll initially recognize the sponsor, and then we'll go through our witness list of witnesses who have asked to speak on these two bills. So at this time, we'll call House Bill 1389 and 1390, and I'll recognize Representative Terry Nolwitz. And if you'd like, Representative Nolwitz, you can testify from whatever's most comfortable for you. So, all right, if you would just hit your button. All right, we'll go ahead and hear from you at this time if you'd like to present the two bills.
Thank you so much. Good morning. Thank you, Chairman Abstration, for having me here this morning, to the members of committee for being here and being open to learning about these two bills. We are talking about House Bill 1389 and House Bill 1390. For House Bill 1389, we're working from LC 480455. For 1390, it is LC 480545. And I'm mentioning them both, as the chairman mentioned at the start of this hearing, because I anticipate that as this conversation continues, we're going to be talking about both of them often in the same conversation. We have a lot of outstanding witnesses and experts in the field of labor and employment rights here with us this morning, and I'm very excited for them to share their insight with you. Before we begin, I wanted to just give a little bit of background and insight as to how we arrived here this morning. You may remember that in 2020, literally on the eve of the pandemic, like March 10th, 11th, 12th, right before everything ground to a halt, crossover day in 2020 was March 12th, which I'll never forget because it was my daughter's birthday. And it's a terrible, terrible way to start your 13th year on this earth. But Chairman Abstration and our colleague B. Wynn, along with other bipartisan sponsors, were moving forward with House Bill 1121. That bill would have amended Title 51 to provide a right of action for sexual harassment against a coworker or an employer. During that session, the bill did not cross over. A lot of great bills did not cross over that session, but it was given a favorable reading from the House committee. We know that Georgia is the #1 state for business, but we aren't the #1 state for workers, especially when it comes to the issue of workplace harassment. Just this week, an article in the AJC noted that Georgia is indeed ranked as one of the worst states for women, with a metric that includes economic opportunities. Georgia has no state law that protects workers from harassment. And in fact, we are one of only about 3 states that does not currently offer these workplace protections that we're going to be discussing in this hearing room today. We know that with the EEOC, odds are slim at the federal level that a claimant's case will even be heard. And that's something we'll also hear more about this morning. Enacting these protections is a good thing for Georgia. It's good for women in Georgia, and frankly, it is good for businesses in Georgia. We know that in Georgia, women are almost 66% of the low-paid workforce, and we also know that just about any employer you talk to will attest that they are having a genuine struggle finding and keeping workers right now. These bills would mean better workplaces for all Georgia workers, and I have no doubt that in a tight labor market, employers would benefit. Plus, this legislation gives employers clarity about what harassment is, and this will arm businesses with the means to prevent and stop harassment. Harassment has an unquestionable human cost. But when there's harassment in a workplace, there is also a bottom line issue for business owners, and they will see this through decreased productivity, increased absenteeism, and higher turnover. So I'm going to point out just real quickly what is in the bills. In HB 1389, this is the Georgia Safe Workplaces Act. Lines 14 through 42 include definitions designating the claimant, the employer. It defines the term sexual harassment and workplace harassment. Line 43 begins the description for the right of action for claimants. You see in line 53, we have the protections against retaliation. Line 60 sets forth the criteria that shall apply to determining whether conduct constitutes harassment. Line 98 specifies that any action must be brought within 3 years to the date of the alleged harassment, and line 100 details the affirmative defense for employers. Again, there are several witnesses that have signed up to speak to this bill and to House Bill 1390. House Bill 1390 offers specific protections against retaliation for workers in county and municipal governments. I will note here that state employees currently have protections like this through the Office of the Inspector General. Lines 10 through 25 are the definitions, again, of workplace harassment and sexual harassment. And you'll see that this language echoes HB 1389. Line 26 is the right of action for a claimant when they face retaliation from a county or city employer. I can't remember if I noted in House Bill 1389, line 100 details the affirmative defense for employers. This legislation is intended to be straightforward. I hope that it is. I welcome the witnesses who are here today to speak on behalf of this legislation. You are probably familiar with my background in municipal government, and I can tell you unequivocally that every Georgia resident and business would benefit from workers in our cities and counties having the protections in place that are detailed in House Bill 1390. And with that, I'm going to move this over to the experts.
Thank you for your presentation. We have some witnesses signed up, and then if anyone didn't make the sign up list, if you just want to let me know, we want to accommodate anybody who wants to speak on these issues for these two bills. So the first witness that I have is Elaine Hudson. I'd like to come forward here to the witness chair. Be great if you would just introduce yourself and then tell us anything that you want to share with us.
Absolutely. Thank you, Chairman, Administration, and fellow committee members. My name is Elaine Hudson, and I am the Director of Advocacy at the Ywca of Greater Atlanta, where our mission is to improve the lives of women and girls in the state of Georgia. As a member of the Respect Georgia Workers Alliance, I would like to express our support for HB 1390. Sexual harassment is widespread, and it stands in the way of workers' equal opportunity and economic stability and the right to live with dignity. Sexual harassment at work makes its targets, the overwhelming majority of whom are women, feel unsafe and unwelcome. It interferes with their ability to be productive and successful, and it hurts their short and long-term mental and physical health. Sexual harassment and employers failing to address harassment or retaliating against its victims contribute to women being pushed out of their jobs, and it can lead women to avoid work or leave a profession altogether. However, people will not speak up to report harassment if they feel they will be retaliated against. Gaps in state law have left many of those most vulnerable to sexual harassment without meaningful legal protections. Instead, the survivor suffers retaliation for reporting harassment and is pushed out of work. 1 in 3 women alleging sexual assault also alleged retaliation in a 2018 study of sexual harassment charges filed with the U.S. Equal Employment Opportunity Commission between 2012 and 2016. More than 71% of survivors who experienced workplace sexual harassment faced a form of retaliation, including termination, being sued for defamation, and denial of promotions. The most common form of retaliation was termination. Moreover, women are more likely to hold public sector jobs. We are teachers, we are sanitation workers, we are public safety officers, we are first responders. All professions we have come to rely on more during the global pandemic. HB 1390 makes Georgia safer not only for women, but for all workers. On behalf of Respect Georgia's Workers Alliance, I ask you to support this bill. Thank you.
So, and you do have a question, Representative Dreyer.
Yeah, thank you, Mr. Chairman. YWCA has worked on this for years, right?
Yes.
Okay. And my question is, there are a lot of issues facing women in society, and you have prioritized this issue in Georgia for years. And I want to know why your organization chose this issue to put so much time and energy behind.
Yes, thank you, Representative. What we have learned, or what we already knew, but it became even more pronounced during COVID-19, was that women are the primary breadwinners in most households in Georgia. And they also are more likely to work in professions where they are highly vulnerable to sexual harassment. So this is an issue that not only affects women individually, it affects their families, it affects their children, it affects their livelihood, their ability to pay their bills. And it also affects men. It affects all workers, because if you have a workplace that has a culture of sexual harassment, no one is immune. Some people are more targeted than others, and it disproportionately affects certain workers. But at the end of the day, workers are going to be less likely to be productive, to perform at their highest ability. A business is going to have high retention. Low retention, excuse me, high turnover. And so we just feel like this is a 360 a solution to a lot of issues that are plaguing our state.
Thank you. Thank you, Mr. Chairman.
Thank you, Representative Fleming.
Thanks for coming today.
Absolutely. Thank you.
My question to the witness and to Mr. Chairman is obviously what we have in front of us is, I assume, would be a purported change in Georgia law. So my question goes to, and you may not be the one to answer this, Mr. Chairman, but we may have a witness later. What is the current status of Georgia law as it interacts with federal law on this issue, and how does this change it? That helps me put in context the rest of the testimony we'll hear.
Well, I think that's a great question. And what I'll do is maybe try to give an overview, and Representative Nolwitz can maybe fill in the gaps that I leave, and other witnesses. But there is no current cause of action in Georgia state law for what we're discussing here, and only relief is available through the federal system currently.
So under case law, there is no cause of action.
There's no cause of action that I'm aware of.
Okay.
I'm not an expert in this area like we have in the room here.
I figured we would have some attorneys that would fill us in on that.
Yeah.
Thank you.
I'm sure there'll be ample opportunity also as we're discussing this issue, if there are other means that maybe I'm unaware of, for us to get into that. Okay, Representative Nolwitz, anything you want to add?
No, I want to thank you, Elaine, for being here today and for sharing that insight, because I think that knowing that women are the primary breadwinners in Georgia, I think that's a stunning data point that a lot of people don't necessarily think about. And I think that if we want our Georgia families to thrive, we need frankly, if we want our businesses to thrive, we need all of our employees, and especially our women, to know that they are safe in their workplaces.
Thank you very much for being here, Ms. Hudson.
Thank you, Chairman. Thank you, committee.
All right, next we'll hear from Rachel Shanklin. And if you would, when you're introducing yourself, please correct me if my pronunciation was incorrect.
No, that was actually perfect.
All right.
Thank you so much. All right. Good morning, Chairman of Administration and members of the committee. My name is Rachel Shanklin. Let me fix my chair. I am the Georgia Outreach Manager for Small Business Majority. We are a national small business education and advocacy organization committed to empowering underserved communities, such as women and people of color, to start and grow a business. We engage a network of more than 85,000 small businesses across the nation. We have about 4,000 in Georgia right now, and 1,500 business organizations to advocate for equitable public policy that will promote business growth. I'm here today to testify in support of HB 1389. Many small business owners think that workplace harassment policies are unnecessary given the size of their business. However, as my colleague just said, no business is immune from the risk of harassment, no matter its size. If an employee has been subjected to workplace harassment, they can sue the business. To reduce the likelihood of a lawsuit, businesses must take measures to train and educate their employees. According to the Equal Employment Opportunity Commission, 67% of small businesses do not have sexual harassment policies and training in place. Businesses of every size and every industry should take steps to safeguard against harassment in the workplace and protect employees. Without staff to educate and train employees about harassment in the workplace, small businesses are particularly vulnerable. A lot of the businesses in our network are those mom and pop shops. They are, less than 10 employees or independent contractors or solo entrepreneurs. Not only do these small businesses lack policies and procedures to combat harassment in the workplace, they typically don't have the resources to settle a harassment claim or complaint, or having the capacity to hire legal counsel. By creating a work environment where small business owners and employees feel safe, we can improve employee retention and morale. This bill provides clarity to employers about what constitutes unlawful harassment, which will help employers in the future prevent and stop harassment. In turn, this will also help employers avoid liability and business costs, such as decreased productivity, increased absenteeism, and diminished recruitment and retention. This legislation will also ensure that all businesses are playing by the same rules and operating on a level playing field. The Georgia's Safe Workplaces Act would make Georgia an even stronger leader in attracting and retaining businesses in our state. Small Business Majority supports HB 1389 and urges the committee to pass this legislation as we continue to support Georgia's smallest businesses. Thank you.
So Ms. Shanklin, I know the sponsor outlined that House Bill 1389 concerns private businesses. House Bill 1390 concerns city and county governments. Does your organization have a position on House Bill 1390?
We do not, only on 1389.
Okay,
for the
all
private
right.
businesses.
Is there a reason that you're distinguishing between the two?
We specifically work with small business owners, not in the city or municipal level. So that is where our stance is at the moment. Not to say that we wouldn't come out and be in support in 1390. We just have not taken a stance on that yet.
Okay, all right. Thank you so much for being here. I don't see any questions.
Thank you so much.
All right, next witness is Grace Starling. Morning.
Good
You'll just
morning.
introduce yourself and then the committee will hear anything you have to say. Thank you.
Good morning, Chairman Frustration and committee members. My name is Grace Starling, and I'm a labor and employment attorney here in Atlanta at Barrett and Farahani, where I represent Georgia workers who have faced discrimination or harassment in their workplace. I'm testifying today in favor of both House Bill 1389 and 1390. Sexual harassment occurs in all industries and all occupations. This is a good bill for all stakeholders, workers, employers, and patrons of businesses. Georgia is currently one of the only states in the country without state law protections against sexual harassment. There are three major reasons that this bill is needed. The first, this bill gives Georgia the ability to control the law around the issues for local businesses. And Representative Fleming, I believe this goes directly to your point. This is an issue that should be handled by Georgia for Georgia employees. We're not Florida, we're not Alabama. The case law in the federal courts is for the 11th Circuit. There is common law state negligence claims that can be brought if there is prior knowledge by an employer of a harassment situation. However, those laws don't provide for enumerated affirmative defenses for an employer. It's less clear how an employer can prevent those kind of claims. So it actually harms those businesses to not have a codified statute protecting workers against sexual harassment. We also want to clarify for employers what they should and should not do so that they are not needlessly subjected to litigation. The federal law is frankly all over the place. So employers don't necessarily know why they need to do what they need to do. And because of that, Georgia employees are not protected. And we all want safe workplaces. Again, for all stakeholders, that's the ultimate goal for your business, for your employees, and for your patrons. A retention of a workforce and the economic interests of employer align with good public policy, and prevention of sexual harassment is good public policy. Happy employees are more productive. And I believe was it Rachel? Yes. I believe as Rachel mentioned, the less absenteeism, greater productivity, and all of those things amplify business in Georgia. Also, businesses have to expend greater resources when there's more turnover of a workforce. We want our local corporations to thrive. And when they have to deal with morale issues because of a bad employee or an employee who hasn't been trained or doesn't know better, that is bad business. Especially with the great resignation that we're currently seeing, it is more important than ever that our corporations can attract and retain talent. The corporations that are adopting these safe workplaces already are retaining talent. They're already building better business models. We want to help all local corporations get there, and we've seen how these policies can help them. The second reason, and again, Representative Fleming, I think this will go to your question. This bill creates actual remedies that are codified for workers when they experience sexual harassment or retaliation in the workplace. This gives a bit of control back to the Georgia legislature to define things like affirmative defenses, damages, remedies, and lay out the kind of factors that a court should look at. Common law is often just that, a mess. It's a bit of a mess. It's not, it's developed over time. And then when the legislature realizes that this is an issue that has developed to a certain point that it needs specifics, and it needs specifics in a statute, that is often when we see things that are in common law become codified and become causes of action. In the federal courts, the dismissal rate for these cases, for sexual harassment specifically, hovers around 94 to 95%. Now that was our last published study by our firm. That is actually increased to, we estimate, about 98%. The law in the circuit leaves most victims of sexual harassment without any viable legal remedy. It discourages workers from coming forward, and an employer can't address issues if they don't know about them. The third reason is that this bill incentivizes prevention and is good public policy. I touched on this briefly in the first point, but the affirmative defense that is specifically listed out in 1389 incentivizes companies to create policies against sexual harassment and communicate these to workers. The prevention methods have been shown to significantly reduce incidents of sexual harassment in the workplace and make it safer for everyone who works there. When workers are educated on policies and they have those policies given to them, they utilize those policies, and employers are better able to know what is occurring in their workplace. I'm happy to answer any questions you have about the policy reasons for this bill, specific language as drafted, or the law as it currently stands. I'm also happy to address any issues or concerns now or following the committee hearing. I can provide my contact information as well if anyone would like to set up a time to speak. I sincerely thank you for your time today and hope that we can take significant steps together to achieve safety in Georgia's workplaces. Thank you.
Ms. Starling, thank you so much for your testimony. Just as I attempt to break this down, it seems that there is the question as to cause of action when there is harassment within the workplace, the potential need for action if a supervisor fails to respond to that harassment, and then maybe a third broad area of retaliation if a report is made. Is it fair to say that you feel that House Bill 1389 addresses all three of those areas?
Chairman Administration, I would agree with that. I think specifically with the cause of action, right, on lines, as Representative Manolowicz mentioned, 43 through 52, we have that specific cause of action for workplace harassment. And these three items are enumerated. So the first one is when a supervisor is acting, and and you'll notice between 1 and 2, the standard is different depending on if it's a supervisor or a non-supervisor, which I think is significant because we see in our law, in common law as well as in statute, that the knowledge component for supervisors in other types of cases often is imputed toward the company. That's why we can, admit statements of by supervisors in court, because they are speaking as the corporation. So I think you'll see that in 1, that knowledge component of the business is missing when a supervisor acts. In 2, it is there is a knowledge component that knows or should have known that either a non-supervisor or third party, and then it goes on to enumerate the different types of third parties. I think that this is an important distinction because it gives those businesses the opportunity to put into place policies for knowing or should have known. So if they have a policy and someone didn't engage that policy, that might be a way for them to defend against the knowledge component if a coworker is harassing another person and they're at the same supervisory level or they don't have a supervising position. So I actually think that that cause of action is comprehensive and really takes into consideration the knowledge that a supervisor has, and then imputes that up to the company, and then also provides businesses for the ability to defend against that kind of cause of action based on that language. That actually goes to the second point as well. The supervisor failing to respond, I think, is encompassed in C2, which is line 46 through 49. Because of that knowledge, the employer having knowledge, but it's also in the affirmative defense, which is lines 100 through 106. And also there is some good language in 107 through 115 about policy and programs for prevention and addressing harassment, and what businesses need to do. So I think that there are some good protections baked in for employers about that, but also that there is the cause of action if a supervisor fails to respond. With the retaliation piece, that is its own cause of action, again, 53 through 60. 53 through 59. And this cause of action for retaliation, I would say that this is extremely important. And I think, I'm also here to testify in favor of 1390, pulling that out for county and municipal employees is critical because retaliation happens so often. And I don't think you don't necessarily realize how much a worker fears being retaliated unless you have felt that fear yourself, or you hear from someone after the fact that they were so afraid of losing their job. I mean, and the thing that I often see with my clients is that this is their livelihood, right? This is how they put food on the table. This is how they put a roof over their family's heads. And so the question comes to them, do I grin and bear it? Do I just take it and be able to provide for my family, or do I report and risk losing my job? The issue with Title IX, with Title VII as it currently stands with retaliation is that it's for businesses of 15 or more employees. Most of the time we see sexual harassment and retaliation, and exactly as Rachel and Elaine pointed out, in smaller businesses, these local businesses that don't know that they need policies, that don't know that there's good reason for these prevention measures to be already put in place before you have a situation that happens. So I think that the retaliation provision is robust. It includes the workplace harassment, which is defined in lines 36 through 42. And I also think that this is going to incentivize employees to come to their employers, and employers can actually fix problems before they become bigger issues, which I think is the ultimate goal in achieving safe workplaces. So yes, is the short answer.
That's very helpful. Maybe I'll ask a compound question here so you can kind of take this where it needs to go in your response. But there have been questions about the appropriate place to put this cause of action for either, and maybe I'll apply this question to both bills that are before the committee today, but should it be in Title 34 as is proposed here, or should we be looking at torts as an appropriate place in the code to put it? And then also there's been a discussion about a whistleblower type treatment versus a cause of action. If you could just speak to that, Ms. Starling.
Sure. I actually think that's a great question, Title 34 or versus putting in torts. It's a really good question. Could I research that and get back to the committee?
Yeah,
I think that I don't want to provide a response that's not informed, but I think I can speak to the whistleblower portion. So the specific cause of action for retaliation in 1389, as I very briefly mentioned, hold on one second. So that's 53 through 59. That incorporates workplace harassment, which if you'll notice on 36 through 42 is defined differently than sexual harassment. There are two separate definitions in the bill. So workplace harassment includes many of the protected characteristics that we see in Title VII and creates a retaliation statute for that purpose. So this, I believe, would encompass the kind of whistleblowing. Now, it depends on your definition of a whistleblower, right? Because there are like workplace safety, right? Like, so like OSHA is not necessarily I wouldn't say would necessarily be encompassed by the definition of workplace harassment here. So I don't know that like complaining to your supervisor about having to be on the road too long if you're a trucker and then being terminated because of that would be covered in terms of that kind of whistleblowing. But in terms of workplace harassment and discrimination, those kind of instances of whistleblowing would absolutely be covered by that workplace harassment definition in 1389 as well as in 1390. But I would note too, and as Representative Nelowitz mentioned, 1390 is specific retaliation statute rather than incorporating the language for sexual harassment that is in 1389.
All right. We have a few questions. Representative Oliver.
Thank you. Welcome back to the Capitol.
Thank you.
Ms. Starling's been here before as an advocate, as a law student, so
Yeah, it's a little different on this side. I have my bar card with me today.
congratulations.
Thank you.
And I'm sure we'll hear from Mr. Buckley, who is another expert in this area. I don't do this practice of law, so I'm following up on Representative Fleming's question. Is there a statutory retaliation claim in the federal law?
So Title VII has its own retaliation provision, and that's typically seen in like FMLA has its own retaliation statute. FLSA has its own retaliation statute, ADEA, the ADA. So there's no general retaliation statute like this. A lot of states, though, have modeled
That's what I was gonna
retaliation
ask.
statutes.
How many states have enacted a retaliation statutes?
So I'd have to get the exact number. I know that I know Florida has their Florida Civil Rights Act, which encompasses a retaliation statute. And I could get specific language on that. But I'm thinking of in the 11th Circuit. I don't think Alabama doesn't have one. But in terms of comparing how many have sexual harassment versus retaliation, I think it's a pretty comparable that a lot of states have with their sexual harassment have also looked at that kind of retaliation. I know Illinois definitely does, but I could get you a number.
Finally, Mr. Chairman, if I may, excuse my ignorance. I know that you have to do an EEOC complaint process for the federal statute. I assume that we don't have to do it for this state statute.
That is accurate. So for Title VII, you have to go through the administrative remedies process, which requires that after 180 days from the date of last harassment, you have to file with the
And there's nothing
EEOC.
equivalent in Georgia. I mean, we do have this process through the Inspector General, but there'd be no requirement in this state statute for any kind of administrative exhaustion in that way.
Not as 1389 is currently written. And states kind of waver on that. Some have it, some don't. There's pro and cons to it. A lot of times I think at state level, it can serve as a greater barrier than if this were to be in the tort section, tort claims would have that just aren't present for other causes of action.
Thank you.
All right. Representative Fleming.
Thank you, Mr. Chairman.
How
Thank
are
for coming
you?
today, Counselor.
Thank you.
Where'd you go to law school?
Georgia State,
And when'd you finish?
2019.
2019. You do have that bar card.
Yep.
Yeah. What is, you mentioned this and I apologize for not catching it fully. What kind of practice do you have?
So I do plaintiffs, labor and employment, and
Okay.
I actually deal with sexual harassment cases on a daily basis.
Okay. So you're quickly becoming an expert.
Yes,
So
that's what I mentioned over there. I said, I'm not an expert, but I know some of the answers.
what they taught me is they call it practicing law for
Right.
a reason. 'cause you're always
Absolutely.
Practicing.
Same with yoga, you're practicing.
That's right. Yeah. What is the difference between a battery and sexual harassment as defined by this bill?
So that's a great question. So battery is one of those, one of the areas that is codified. And battery, I believe, is the non-consensual touching of someone. You can also bring the assault if you're fearing the
Sure.
battery, which I think sometimes in workplace harassment, that happens a lot more because of the frequency that you're working with someone. You'll have a battery and then a subsequent several assaults. But the battery is the physical touching, right? But the definition of sexual harassment as in the bill, give me one moment,
Can be non-physical.
can be non-physical. But so I think my page just got messed up. Hold on. Here we go. So this definition has it as sexual advances or requests for sexual favor or any other conduct of sexual nature. But then it's enumerated as A, B, and C. these have to do with the terms and conditions of one's work. So it's a slightly elevated standard as it's currently written. And it goes through the hostile work environment, which is a bit of a higher burden, whereas a battery isn't defined through an employment relationship. Anyone could commit a battery against anyone else. Here, sexual harassment has to do with the workplace. And also, as you said, obviously would include non-physical touching, or non-touching.
So if a touching is in the workplace in a sexual nature and not welcomed, is it a battery?
I would say yes. So a battery can be sexual harassment, but all battery can be sexual harassment, but not all sexual harassment will be battery.
Okay. And I think I was reading and listening and trying to do the same time, which I don't do well, to your Representative Oliver's question. Did she ask how many states have laws that you would say are comparable to what is proposed here?
Representative Oliver asked for retaliation, how many
Okay.
states might have a more
Okay.
general retaliation, which I'm happy, along with the information about Title 34 or in the tort section, I can provide that to the committee.
So you said 98% of cases you estimated 98% of federal cases are somewhere in the high 90s
In the Northern District of Georgia.
are dismissed.
Yes.
Why?
So the burden at the 11th Circuit is incredibly high because of the way the case laws come out. It is based on a hostile work environment, which is a severe pervasive element. The 11th Circuit has found that circumstances such as someone grabbing someone else's crotch and supervisor inviting someone into their own office, shutting the door and forcing them to kiss them, those aren't enough to constitute sexual harassment. Instances of repeated comments that someone might look good and might look hotter in tight clothing, and that they were going to eat them for lunch are considered not enough to be sexual harassment. The standard for severe or pervasive is high. And it's the same. It's the same with racial harassment as well. That's the same standard. It's hostile work environment. Most race cases are brought as a discrimination, but harassment really can only be brought through a hostile work environment claim. So race cases have another way of getting of bringing the cause of action, that's through discrimination, but sexual harassment, which is sex discrimination, can only be brought through a hostile work environment claim.
And last question, if I may, Mr. Chairman, the need for the separate bill for cities and counties, and I assume counties includes boards of education.
We'd have to look at the definition of county. I don't have that in front of me, but
Well, we can figure that out, but it's to waive sovereign immunity. Is that correct? Is that the purpose of the separate bill?
I don't think so. The separate bill, this bill with the sexual harassment is private. And I think that the reason, and you can correct me if I'm wrong, but Representative Vanolowitz pulled out that retaliation piece because there are already some processes in place for county and city employees for sexual harassment. And if
That said, I am all for doing anything I can do to help waive sovereign immunity for
Well,
cities and counties.
I guess maybe that's another question to research. Is that the purpose why we have a separate bill, because we have to deal with sovereign immunity?
That was not the intent when the legislation was drafted. That did not enter the conversation, but that is a very, very good question.
Okay, thank you, Mr. Chairman.
Thank you, Representative Evans. Whose button is flashing? Representative Holcomb.
Thank you, Mr. Chairman. Good morning.
Good
Ms.
morning.
Starling. I see the advocates brought their all-stars this morning. It's good to see you all.
you are my new representative at my new address. So
Excellent. Good to know.
No pressure.
I hear the argument in terms of the business case, and in my mind, this is much simpler than that, which is that everybody is entitled to a safe workplace, and if that doesn't happen, there should be redress. So I'll start with that, and then in terms of the public side, we've had instances where judges have sexually harassed people that work for them. We've had instances where district attorneys recently have sexually harassed individuals that work for them. So we know that this is pervasive. The question I want to ask you is, I have some experience with this, but not a lot. But you just mentioned how difficult the standard is at the federal circuit. I think some opponents might worry that this is just another way to open the floodgates of litigation and everything else. And my sense is that that's not really true, because the bar is so high that usually what we're talking about in terms of these cases are the really egregious, the ones where objectively anybody who is presented with the facts would say that's wrong and cannot stand.
Absolutely.
As a practitioner, can you just give us some context into whether or not you think that observation is correct or incorrect?
Sure. And I think your observation of sexual harassment happening in all spheres is important. I mean, Governor Kemp in 2019 signed his executive order for requiring sexual harassment training in the executive agencies. And that was at the forefront of the conversation then. With specifically to your question, though, about the standards, this bill is comprehensive. It provides for affirmative defenses. It provides for factors that courts need to consider. It's not something that you're not going to have this bill and not know what it means. You're not going to have a potential client come to you and not be able to look at the statute and say, well, let's roll the dice and let's file a lawsuit and see if we can make it work, right? Goes through the factors such as frequency of conduct, duration of conduct, location where the conduct occurred, number of individuals engaged in the conduct, nature of the conduct, which also goes to Representative Fleming's question, which may include physical, verbal, pictorial, visual conduct that is in person or transmitted, whether the conduct is threatening, any power differential between the harasser and the harassed, slurs or epithets, and conduct reflecting stereotypes. So someone evaluating whether or not to bring a case under this can look at these factors, look at the facts that are presented to them by a potential client, and evaluate whether or not there is a true claim. At this point, in the 11th Circuit, the case law is such that unless it's the most egregious of the most egregious, no one's going to bring the case.
Right.
So it threads the in between of the two, right? It allows for a cause of action where there should be one, but it also provides protections such as affirmative defenses, and specific language about the policy, and also factors the court can consider that attorneys can look at when deciding whether or not to bring cases.
Right. And the overall policy here is by putting it into state statute, we send a very strong message that this is not something that is acceptable in the state of Georgia. And in terms of having policies and procedures, we're also saying it's not enough to just have something on the books. You have to live by it. You have to comply with it. And if you don't, then you can be sanctioned. Correct?
Absolutely.
All right. Thanks.
All right. A few more questions.
course.
All right. So the majority caucus chair has a question. Oh, I'm sorry, Representative Dreyer. Apologies.
Yeah, I just want to follow up on a couple points Representative Holcomb made there and questions. And I want to apologize to everybody. I'm a little hoarse today. I coached middle school basketball and I'm always yelling at these kids to get back on defense. But with Representative Holcomb's first point, getting back on defense, like we are setting up clear parameters to defend people in workplaces, particularly vulnerable people in workplaces. And I mean, I want to ask you, I've had conversations with you about cases. I've had conversations with partners at Buckley and Beal about cases that we could not bring, and they were egregious.
Right.
Because the law did not allow an attorney to invest the time and effort that was required with any reasonable guarantee of some sort of return on the end. And at the end of the day, when you and I've talked about those cases, when I've talked about cases with attorneys, Buckley, those are real people that have suffered. Many have lost jobs. Many families have been harmed. And there was nothing we could do based on the current law in the state of Georgia. Right.
That's absolutely accurate. And that is the current landscape of the law as we look at it.
Thank you.
Representative Smith.
Thank you, Mr. Chairman. Thank you for being here with us this morning. I've got some cases I probably need to get your card and send to you. So I've got a little business. So I really appreciate this coming from in the same vein. My mother losing her job when she had me. It's a very personal situation for me in the same sense. I say that to say this, I'm looking at line 36 and 37, and then the next bill, when we get to it,
13.
on HB 1390, but I'm going to go over 1389. Gender identity and sexual orientation. This language here tracks, as I understand it, Title VII, correct?
It does.
Okay, all right. And this is actually
After Buckley Beal's
Mhm.
Supreme Court case, it does.
Right, right. And so this is a pretty big expansion of the definition, correct?
I'm sorry, up from
Of
up-
Title VII, tracking that language.
well, Title VII defines now sexual orientation is included.
Mhm.
Yes. So, and I would,
But not gender identity.
I don't think that did it hold for that? Yeah. So Ed would be the one to talk with you about this. It was his firm that brought that case.
Okay.
But it tracks, it's encompassing all of what Title VII now is to encompass.
Right. So it seems like we find ourselves right in the middle of the culture wars here, especially with the term of gender identity. My concerns here are the threat to religious liberty and conversations at work, as we understand, male and female, that this will be a substantial expansion. And my true concern is, as we imagine these hypothetical scenarios of the water cooler talk and people discussing their religion at work. I mean, basically, we all discuss our religious beliefs with one another, and we have a discourse with one another that generally is always civil. But I have grave concerns as to what this will do to someone's religious liberty. And I'd like for you to just kind of comment on how you see this going, because I'm afraid we're fast approaching where whenever we step in the door of employment, we have to leave our religious beliefs right there at the threshold. And in the public square, we have much need for discourse. So if you could just
Sure,
comment on
I can
those issues.
absolutely address that. So I think it's important to note that for 36 through 42, the workplace harassment is operative for the cause of action for retaliation. So this isn't creating a broad harassment statute based on things like sexual orientation or gender identity, right? If they're tied to, they could possibly be encompassed in the sexual harassment if there's conduct and it possibly relates, but that definition is in the retaliation. So someone isn't going to be, if someone reports that they believe that they are being discriminated against because of their sexual orientation or gender identity, and they are then retaliated against, that's only the time when there is going to be the trigger for that workplace harassment, right? So there's no cause of action against an employee who may be accused of discriminating based on gender identity or sexual harassment, unless it constitutes sexual harassment. It's the employer who's going to be at the subject of the cause of action. And that's the person who, if they retaliate, that's when it would be triggered. So I think that could alleviate some concerns about the public discourse in the workplace, because it's really about the actions of the employer if someone does report that to them, and whether or not they then terminate them, demote them, refuse to promote them, take away pay, then that's really where that comes into. So that would be my response on that, that it's not creating, a general cause of action for that kind of harassment.
Okay, and if I can just follow up, so say if you have an employer, let's just use Hobby Lobby for instance, and on designation for say a form for applying for your insurance, getting signed up for insurance and 401k benefits, something like that, and they have on there male or female on these forms that an employer would use. Could this not be construed, since we're codifying this, but as we know, we live in a great common law judicial system. Could that not eventually one day through case law be construed as harassment?
well, I don't know that would. So in your hypothetical, if an employee were to go to their employer and complain about the form and say that they felt they were being discriminated against based on their gender identity because of the male or female, and then an employer terminates them because of that complaint, that could trigger cause of action. One way to solve that is if you sub in some good faith language that is in Title VII. So, which would put a bit of an onus back on the plaintiff to have to show that they're bringing their complaint of discrimination in good faith to that employer, which is what is in the federal law, is something that has to be proved. So that's one way to alleviate it.
Or we could just take out the gender identity portion of this bill as written.
So, and I hear your concerns, but I think that, and what I'm hearing is that that the harassment as a broader cause of action would subject people to liability for common workplace conversations. But again, this definition is specific to the retaliation cause of action. It's not in the cause of action for 43 through 52. Sexual harassment is included in the workplace harassment definition, but workplace harassment is not included in the sexual harassment definition. So I think that if someone is in honest good faith complaining that they do feel they're being discriminated against based on their gender identity and an employer fires them, they should be able to access that cause of action. But there are more discrete ways, I think, of ensuring that the complaint of discrimination is made in good faith. Honestly, you could probably even put it, one second. Lines 53 through 55. You could put, a claimant shall have a right of action for retaliation when an employer retaliates against a claimant because such claimant has opposed what the claimant in good faith believes to be workplace harassment, or because the individual in good faith has made a charge, filed any complaint, or instituted or caused to be, and then go on. But adding that good faith language there could alleviate concerns about any kind of frivolous discrimination complaint.
Okay, just one follow-up. The definition here and how it tracks Title VII, is this found anywhere else in Georgia Code?
Definition of
That
workplace
includes
harassment.
gender identity. Would this not be the first place that we identified gender identity in the Georgia Code?
May be the first place in Georgia. The thing, though, is when it comes to gender identity isn't necessarily enumerated in Title VII either. It's how it's read into the statute now because of case law. So it's considered to be a form of sex discrimination.
Okay.
By the Supreme Court.
Okay. Thank you.
Representative Fleming has a question, then he has to go to a different committee, and we have a few other members who have questions, if it's all right. Thank you so much for your, for your time. All right, Representative Fleming.
Thank you, Mr. Chairman, for allowing me to ask that before I have to step out. I was trying to follow up on something you said in response to Representative Smith's question. He was talking about the expansion of the definition of workplace harassment and what kind of claim that you would bring, and you were tying it to need to be tied to sexual harassment. But I was speaking with my two senior partners to my left, right here, literally and figuratively to my left, and online.
But not senior.
That's all right. Well, they're going to be senior because I'm going to blame them if we didn't get it right. But on line 43, it says a claimant shall have a right of action for workplace harassment. Should that be sexual harassment there? Because otherwise you're creating a new claim for workplace.
That should be.
I think that, no, yeah, I think
that should
is
be
a very
sexual
good
harassment.
question.
Okay.
Yeah,
Okay. That was my
that should be-
question
yeah.
because his question was correct.
Yeah, that should be sexual harassment.
Okay.
And that's how I believe the bill was
Okay.
conceived. It may have just been because the definition was the one right before the
Sure.
line.
Thank you, Mr. Chairman.
All right, thank you.
Good catch.
Chairwoman Rich.
Yes.
Thank you. And thank you for explaining the bill. As a woman, I can appreciate its intentions. I'm more concerned about maybe some unintended broadening of this cause of action. If you go to line 95, conduct may be workplace harassment regardless of whether or not it occurred outside of the workplace. So a couple issues.
That should also be sexual harassment. I
Okay,
believe.
all right.
Just,
Oh, that's sexual. Okay, I see. So what if there was sexual harassment conduct that occurred outside the workplace and the employer wasn't aware of it? So if there was an issue where maybe the claimant and the bad actor were in a social environment that was not related to work, or maybe they just passed each other in the grocery store. The way that I read this bill is that conduct, that employer could be liable for that conduct. And I'm thinking that may not be what you intended.
so I would say that's not necessarily accurate just because of the cause of action language. So lines 46 through 49, where it says against an employer that knows or should have known that either a non-supervisor employed by an employer or third party, and then goes on, engaged in, I think, again, that should be sexual harassment. But that portion about the employer knowing, I think would resolve that issue about, if this is occurring outside. The question would come to, well, should the employer have known that this was happening if the conduct was occurring outside the workplace?
And how would that happen? What if it were posted on Facebook? So it's essentially public, but the employer didn't see it. Should he have seen it? Should he have known?
I would say let's say an employer has a policy of monitoring their employees' social media accounts, then you can make the argument, I think, that they should have known. But there's no, unless an employer is voluntarily kind of assuming that duty to supervise their employees to that extent, I think you have the argument that there was no reason they should know. If someone brings the Facebook post in and says, and starts talking about it everywhere, and a supervisor glances and sees it and walks by, I mean, that's a question of fact, right? Whether they should have known. But I think in that truly outside the workplace environment, it's going to make it more difficult for that. And I also think with the factors that should be considered, 1 second, I'm sorry. Location of the conduct. So line 77. This line, I think it's, I see this a lot in hotel cases where someone is sexually harassed and they're in a housekeeping position, and they're sexually harassed in a hotel room and it's isolated and it's away. I think that can also show a heightened form of harassment. But I think you could also argue that the location of it, if it's occurring outside the workplace, you could argue that it's not necessarily that kind of harassment. So I think having that in the factors to be considered by the court is important on both sides.
Okay. What about the claimant, the people who can bring a cause of action? So it goes to line 14. A claimant is an individual who experiences harassment or related retaliation. Retaliation, whistleblower, I understand. But that combined with some of the other factors in the bill makes me concerned that maybe just an employee who is not even a part of the protected group, but happens to see it or witness it. Am I reading that correctly, that employee has a right to a claim against the employer?
So I think for harassment, I know that it's specifically discussed for retaliation, it's specifically discussed.
And
that
I'm not
someone-
talking about
Okay.
retaliation. Yeah, but I completely understand that.
So
There's a whistleblower, but what if there is an employee who watches and does that employee, even if he or she is in the protected class or not, it reads to me like that person does have a cause of action. And so it sounds like maybe that was not the intent.
Well, that can happen in federal law. There in other circuits we've seen where someone who witnesses harassment may have a claim for it. It's not a very strong claim.
And would that be a person in the same protected class?
Yeah, like an employee. I think here, I don't know that they would because of how sexual harassment is defined, and then how the cause of action. I think specifically because of the definition of sexual harassment with A, B, and C, it talks about how it alters the terms and conditions of one's employment. So I think with the incorporation of the claimant definition, but also and the sexual harassment definition, those together would make it less likely that that would be the use of it.
Would you be amenable to amendments at some later date to clarify both of these issues?
Sure, I did not draft the bill, but
Oh, okay.
yeah,
that's it.
Yeah, one thing I wanted to add with regards to harassment that's taking place outside of the workplace, I do want to be clear that workplace harassment that happens outside, like say if it's a boss groping an employee at a conference, that's still workplace harassment. And
And that would
it
also
should still be
covered-
actionable. Yeah.
That would be
Okay,
covered by the knowledge.
and that was
component
not-
for the
that was not my
supervisor.
issue.
Right,
I'm not-
right. But looking at, the standard of liability here is the standard of liability under federal law. That is my understanding of how this is going. And if you've got, I can give you an example. So you have, and tell me if this is sort of fits in with what your question is. You have a hotel room cleaner who's groped by a non-supervisory employee from another company who's refilling the vending machines. So that's, you've got a lot of different parties at work here. That hotel room cleaner's employee under this bill could be liable if they knew or should have known that the vendor engaged in workplace harassment, if they knew or should have known. The vendor's employer could be liable if they knew or should have known that the vendor engaged in the harassment. The hotel room cleaner could hold the vending machine employee directly liable. Is that?
No, I was
Okay.
thinking of much looser because your bill actually goes further than that.
Right.
It goes further. So if there is a client of an employer who is out at a party or in the grocery store and the employer's employee experiences some form of harassment, your bill covers that. And I don't think that you mean to, and that especially since you just said that your standard of liability is based on the federal and is not meant to go beyond what the federal liability goes.
I would say it doesn't cover that because of the definition of sexual harassment where it talks about the terms and conditions of employment. The question would be, can a client really have the power to alter someone's terms and conditions of employment?
Well, and so I think that you leave a lot vague and unanswered here. You leave a lot to be litigated, and litigation is expensive. So what I'm asking, and I shouldn't be asking you, I should be asking the author, is would you be amenable to language that would tighten this up to save a lot of litigation for our employers?
I'm definitely amenable to the discussion. And I think that I think that discussion is probably going to continue as the other witnesses come up and discuss this also. And one thing I do want to, going back to what Chairman Fleming had raised in the issue with line 43, and I'm sorry, this is non sequitur, but I wanted to point this out while my microphone is on. If you're looking at 43, I think that if we look at line 41 and 42, where it says the term workplace harassment includes sexual harassment, I think that clarifies the meaning of workplace harassment. So I don't necessarily think we need to strike workplace and replace it with sexual per that definition in line 42. You do?
I
Ms.
would.
Starling.
I would.
You-
I would.
Okay.
I don't want to, but I
Okay.
think that, yeah,
Thank you.
it would be clear.
All right. We have a few other questions. We have Representative Leverett.
Thank you, Mr. Chairman. Ma'am, I just want to say you're a heck of an impressive witness. You've shown such a deep knowledge of this area, and you've shown tremendous stamina.
Thank
in the number
you.
of questions you've taken on.
Years
And
since I've been here.
Well, and I apologize
No,
for
no,
adding
I love it.
to the burden,
I love it.
but I want to kind of go up get a few miles high and get the view down. So there is a federal law that deals with sexual harassment, Title 7. And is that it, or are there some other federal statutes that deal with sexual harassment?
That's it.
Okay, that's it. So, and I'm gathering that the manner in which that law, and so you could sue in federal court on those. Does federal court have exclusive jurisdiction, or could you also sue in a state court and insert a Title 7?
You can also
claim?
sue in a state court, and then the defendant could choose to remove,
You
and
can get the removal.
you can get the removal, but you got to get the removal and not get the fees against you.
That's never really fun trying to, because I hate being in federal court, but that's a topic for another day. So you could sue in state court on a Title 7 claim, but I gather from your earlier testimony, the construction of that statute, at least in the 11th Circuit, has limited the viability of a lot of claims that you might feel sort of intuitively or from your gut really does demand some redress.
And I would say sexual harassment specifically is where the 11th Circuit has really hollowed out any remedy. I mean, more than any other form for race, ADA's disability, but for race, for gender discrimination that's not sexual harassment, there are pathways forward. With sexual harassment, there really is a very, very limited path forward.
And that's the high dismissal rate you referred
The
to.
high dismissal rate, and it's also the case law around it.
So does this, and you're gonna have to kind of spoon feed me because I just don't know much about that area of the law because it is sort of specialized and I just have a general civil practice. But does much of the language in this bill take Title VII and some of the the common law construction of that statute and try to codify it to make it Georgia law?
It does. So specifically, kind of as I mentioned, the knowledge portion in the cause of action 43 through 52, that would mirror common law negligence claims against an employer for negligent hiring, negligent failure to prevent sexual harassment, or negligent supervision, negligent training. So that knowledge component, I think, is codified there. The affirmative defense actually codifies something that really is very slippery. And I think the affirmative defense is better for employers because it actually gives them a statute to say, an affirmative. Now it's kind of, well, we tried to prevent it, we did this, but here they can point and say, well, this is the affirmative defense for this cause of action, which they don't necessarily have for the common law negligence.
And when you say common law negligence, you mean a state law common law negligence claim?
Common law, yes. So
Okay.
like like the tort you'd learn about in employment law, that's like failure to hire or failure to prevent XYZ in the workplace.
So that currently that I assume is a state law claim you could bring in
It's-
connection with one of these claims.
You could bring it. It's the law on it is still very unclear. There's a current appeal pending right now with the Georgia Court of Appeals on a motion to dismiss for that kind of a claim. That's the Kenneth Hunt case, but it's nowhere near as comprehensive as this. This is factors, affirmative defenses, remedies.
And you're referring to lines 100 through 106.
For the affirmative defense, yes, 100, 106. And then also there is kind of, this isn't, well, it doesn't have a letter. Hold on. Yeah, where it goes evidence, I think there should be a letter there. Yeah, there is. There's a missing H because it says H1 underneath it. So evidence of a mere existence of policy, and kind of goes into that of what may not qualify. That's not in the common law clearly enough for anyone to be able to follow to the point of in good faith trying to avoid liability.
So I'm guessing that you're talking about lines 107, 108.
107 down to 118.
So you believe 107 and 108 should be part of H?
No. So do you see on 109 where it says H1?
Yes, ma'am.
I think 107 is supposed to have an H.
I don't think it, but I guess we can look at that. And I don't want us to get down the rabbit well
Okay.
on that right now. Just it's in the statute. So
Yeah, I just can't tell. It's the only, I can't tell if it is a continuation of the affirmative defense or
I
just,
think it is. I think
Okay.
it's part of G. I think it finishes up with it names the two affirmative defenses, but then it says that evidence that you've got a policy
it's not enough.
alone is not a
Yeah. So,
sufficient.
and that's an area too, if there was concerns about that for an employer where that could be expanded and that could kind of go into that factor analysis.
And so my understanding is your understanding of the bill was that the workplace harassment definition is not, the bill is not supposed to create an independent cause of action for workplace harassment, just for sexual harassment, but it does create a retaliation
Cause of
claim
action
that
based on.
involves either sexual harassment or workplace
Absolutely.
harassment. Okay. And one other question I had on lines 47, 48, where we're talking about conduct of a subcontractor, contractor, vendor, or consultant. And this sort of goes to Chairman Rich's question that it would seem that you're making the employer liable for the actions of an independent contractor. And I'm just curious, is that currently the law under Title VII?
So Title VII, when it defines individual, employee, and it's talking about employee versus independent contractor, the focus is really on the person who's experiencing the discrimination or harassment. So that would not be out of line with Title VII.
Okay. And one final question, then I'm going to let you rest. So my understanding is there's a sense that the federal law has been unduly restricted by court decision. And so as part of the purpose of this bill to expand it out a little more so that at least in state court, you would be more likely to have redress than you would have been in federal court.
That is accurate. I think also, and a lot of these sexual harassment cases are older. So the facts may not have seemed as egregious at the time. There wasn't as much information and knowledge about the subject area as there is now. And we know how precedent is, right? It's sticky. So I think that is exactly what this is trying to do, kind of to middle of the road from going no remedy to all the remedies to just a remedy for the person who needs it.
And trying to redress some of the restrictive cases. Okay. All right. Thank you so
Thank
much.
you.
Appreciate it.
All right, Representative Evans. Okay. And I know Mr. Buckley was referenced several times. Is it all right if I add you to the end of the witness list, Mr. Buckley, just if there are any other questions that members have? Would that be okay?
You want to go now?
Well, if it's all right, maybe let's hear from the other witnesses who
Yeah.
signed up. I want to be respectful of the folks who followed the procedure that we asked to follow. Okay, so thank you so much.
Thank you.
Ms. Starling, and really appreciate your time. And sounds like your willingness to even field
Absolutely.
questions offline if members
Yeah,
of the
and I
committee
can-
have questions.
Well, it's public. I can give you my email. It's
I tell you what, if you want to, you can. It's probably on the State Bar website, but if you would maybe provide it to Anterica Fuller, the administrative
I have her
assistant
email,
office, she
yes.
can email it out to the
Okay,
committee
perfect.
members. Wonderful.
Thank
You so
you.
much.
Thank you all.
All right. Next up is Micah Whitfield. Good morning.
Good morning. That's a hard act to follow, but first, thank you, Mr. Chairman, Administration, and the committee members for taking time to hear our testimony for HB 1389. My name is Michael Whitfield. I'm the Georgia State Director for 9 to 5 National Association for Working Women. I'm pleased to speak on behalf of our organization in support for both 1389 and 1390. We see the bill as an important first step in preventing and combating workplace sexual harassment and discrimination in Georgia. 9 to 5, as I mentioned, we are the National Association of Working Women. We're a national membership-led organization dedicated to achieving justice for working women and families. In Georgia, we have roughly 5,000 members. Workplace harassment has been at the forefront of our work since our inception in 1974, and we see it as a widespread problem, as many others have mentioned, affecting workers in every part of our state. We know that it happens in every industry and at every level of employment, as well as retaliation in response to harassment claims is pervasive. We previously ran the National Job Survival Hotline, and during that time, we would field hundreds of calls from Georgia workers wanting support for workplace harassment and or discrimination. We currently run a survivor fellowship that empowers workers who need support, as well as support around sharing their stories and support with employers. The feedback from calls within our state highlighted that Georgia, as mentioned previously, is only one of few states that doesn't have state level protections for private sector workers. In response, as mentioned earlier, several years, we have helped lead bipartisan support to implement protections for Georgia. During the 2020 session, we assisted and supported with HB 1121. In 2021, we formed the Respect Georgia Workers Alliance, which was formed to ensure all workers receive dignity and respect in the workplace. The alliance, which consists of 15 workforce and support organizations in our state, many of whom are represented here today, worked closely last year for HB 549, and very proud to work with Representative Terry Nelowitz, who introduced the two bills now under consideration. I share that brief history because we see the rising need for this legislation in this work, and as well as awareness around this issue within our state. I also briefly want to share 83% of voters surveyed want policymakers to focus on ending harassment at work, and 68% of voters think addressing sexual harassment and assault should be a major or top priority for elected officials. We hear the stories from these women every day and their families and the impact that it is having on them. And we fully support both HB 1389 and 1390, as I mentioned before, an important step in recognizing the needed legal protections to combat and prevent sexual harassment and retaliation in the workplace. I thank you for your time.
Thank you very much. Are there any questions from Ms. Whitfield? All right, seeing none. Thank you so much for being here today. All right, next we have Pamela Grisham. Oh, I'm sorry, she's online. So Ms. Grisham, we can see you're unmuted, and if you would just introduce yourself and then proceed with your testimony, we would appreciate it.
Yes, thank you. Again, good morning, Chairman Administration and members of the committee. Again, my name is Pamela Grisham. I am a resident of Decatur, Georgia, and I am also a fellow with the Respect Georgia Workers Alliance. I am also a survivor of workplace harassment and discrimination, and I am speaking in support of HB 1389. I have personally been directly impacted by workplace harassment and discrimination. I was racially discriminated against by my coworkers, and then I experienced retaliation once I reported the discrimination. This led to me eventually leaving my job, which had negative consequences for myself and my family, and this also had a big impact on my future career. It was hard for me to find another job, to be able to work up under people, because I was just afraid. I didn't know what would happen. And I didn't want to experience that again. I experienced a lot of stress and anxiety. And as a result of that situation at my job, and I know firsthand the impact not having the necessary protection at work can have. Although I was forced to leave my job, I know the harassment continues at this place of business, which saddens me. This is why state level protections are needed for workers. I was never told about my legal rights when I complained about the discrimination which I was experiencing. I did go to the administrative department, and my complaints were just brushed off as if it was my fault. I truly believe state laws are needed so that employers are clear about their responsibility to keep workers safe and free from harassment at work. Thank you for allowing me to provide my testimony today. And again, my ask is that you please vote yes on HB 1389 so that no more workers have to face the hardship that I have endured. Thank you.
Thank you very much. Don't see any questions for the committee. Thank you for being with us today, Ms. Grisham. Next up, we have Nafisa Robinson. And Ms. Robinson, very good. You're unmuted. And if you would just introduce yourself, and please correct my mispronunciation, if any, and then we'll hear your testimony. Thank you.
Good morning, dear Chairman Administration and members of the committee. And my name is Nafisa Robinson, and I'm a fellow of Respect Georgia Workers Alliance. I live in Atlanta, and I'm a survivor of workplace harassment and retaliation. So in 2016, I was injured at work, and I was placed on light duty. I was constantly harassed by my manager until I was ultimately fired with no explanation in 2018. Prior to my injury, I was labeled a model employee. I was elected to serve on several committees. I was given the privilege of training new hires because of my knowledge was well respected. After my injury, when the mistreatment began to be a pattern, I tried to advocate for myself and others who was also being discriminated against. I was then retaliated against and ultimately fired without cause. There was no laws in place to protect me. As a result of being wrongfully fired, I had to find a new career when I was in the career of my dreams. Because of my injury, I cannot do the same type of work I was doing prior to getting hurt. This has resulted in a dramatic pay decrease because I've had to change career paths without needed education or the experience. This financial hardship resulted in my house being foreclosed on and me going into credit card debt. Right now, I'm at the starting wage of where I was 15 years ago when I started my former job. So having workplace protection would mean that I could go to work daily in a safe environment instead of having to worry about things like intimidation and a hostile work environment. Thank you for allowing me to offer my testimony today. I urge you to vote yes on the HB 1389 to create state level protections for workers like me in Georgia. Have an amazing day.
Thank you very much for being with us. So at this point in time, we'll ask Mr. Buckley to come on up. And if possible, Mr. Buckley, if you could maybe take the bills in order. If there are questions about House Bill 1389, I'd just like those separated from questions about 1390.
Sure.
And maybe if you'd like to begin with any statement you'd like to make, then that may trigger some questions from the committee. Thank you.
Sure, and I may be able to address some of the past questions that were made, concerns about religious issues and that sort of thing in the workplace. So, and also about the question of harassment outside of the workplace, because I've got a lot of perspective on that. And just a little about me. My name's Ed Buckley. I've been practicing law in Georgia for 39 years, most of it in the area of employment and civil rights law, and particularly discrimination and harassment in the workplace. I've worked well over 300 sexual harassment cases, but also cases involving racial harassment, religious harassment, national origin harassment, age harassment, you know, every kind of category, disability harassment. So it's a problem. And you know, I was really interested in the testimony of the two ladies online, because the toll that it takes is it's twofold. It's the toll on the individual is obvious. Here's a lady who had a career, and she's now 15 years back from where she should be at this point in her career trajectory. And emotionally, that toll is astonishing and demoralizing. It affects how effective she can even be in the workplace after going through these demoralizing experiences. And sexual harassment, of course, is one of the most terrible forms of harassment, and the emotional toll is astonishing. It affects the productivity of our workers in Georgia. It also, because we do not presently have legislation that protects workers in this way, it sends a message to people who would come to Georgia and work as professionals that this is not a place that protects workers in the workplace. And half the workforce, or better actually at this point, women are not adequately protected. So it's not good for the state. It's not good for industry in Georgia, for people who would like to work here to know that there's not adequate protection. So I will talk about these two bills, 1389 and 1390. I think that they are both long overdue in Georgia for the very reasons that I just articulated. We want to protect our workers. They are our resource. They are what makes Georgia a great business state. They're why we're a great business state. But if we don't protect our workers, those resources are going to go elsewhere. We don't want to do that. And also too, because of the emotional toll it takes, you can cause people to be ineffective. So let's talk about 1389 first. Okay. This is the Georgia Safe Workplaces Act. It's a great bill. There is, and there's been discussion, there's nothing on the books in Georgia that protects women in the workplace or protects other minority groups from workplace harassment. Nothing that protects women from sexual harassment. There are bits and pieces. There are statutes, there are tort statutes, you know, assault and battery. Yeah, you're protected in the workplace. Yes, an offensive touching, an unwelcome touching in the workplace can be an assault and or a battery, both. But that is not adequate protection. And what we need to do is educate businesses, and specifically educate people who work in human resources about the rights of workers in the workplace and the potential liability should an employer fail to protect those workers' rights. And this bill, if employers are notified of this, then they'll have to get up to speed. They'll have to. Time and time and time again, I've seen human resources managers, human resources specialists who are just not educated on the rights of workers under these statutes. And it's kind of astonishing, but it's true, and it's true in Georgia. So this bill breaks down, and of course, we focused primarily in this hearing about sexual harassment and what it constitutes and what it protects workers from, and also workplace harassment. And I want to address the representatives, Mr. Smith's concerns about the overlap between gender identity and religion in the workplace. Harassment generally under the present case law needs to be severe or pervasive. Somebody expressing their religious opinion at the water cooler, we always talk about the water cooler, it might be somewhere else, but somebody expressing their religious opinion is not suddenly going to escalate to workplace harassment. Somebody singling out somebody because of their gender identity and actively harassing them because of it and making lewd, crude comments to them about their gender identity, that is workplace harassment and can be workplace harassment. That is not, as I understand it, harassing somebody because of their sexual orientation or their gender identity. That's not a tenet of any religion that I know of. So it's kind of hard to imagine somebody say, well, my religious beliefs say that I can harass this person or make, unsavory taunts and claims. Sexual orientation, very briefly, our firm brought the case that went to the United States Supreme Court, and a team of lawyers, including Brian Sutherland and Tom Mew, did a spectacular job in convincing the Supreme Court that sexual orientation discrimination is sex discrimination, right? And it was Justice Gorsuch who wrote the opinion, not the most progressive justice on that court, but he read the text of the statute and he said, well, by golly, it is. So those are protected. And so putting those in this statute under section, I'm looking at the section of 5 lines 36 to 42, putting that in this bill, Georgia's not burning a new path or doing anything unusual. Georgia is just doing something that's consistent with Supreme Court case law here. And by protecting people who, based on their sexual orientation or gender identity. And by the way, that includes if the sexual orientation is heterosexual, for example. If people are harassing somebody because they're heterosexual, they're protected under the statute. Gender identity. Well, I identify as a male. If somebody were harassing me because of my gender identity, that would be covered. So, and same with people who identify as female. And there are those who now we know are binary and identify as both. So harassing them based on that is inappropriate and covered by the statute. One other thing about this statute, and there's been a little bit of conversation about, well, you have federal law, you have the EEOC. Isn't that enough? The EEOC is, in my mind, an unnecessary administrative step. And it is a slow and cumbersome administrative step. And based on my observation of over 30 years of the EEOC and interaction with the EEOC, they are not effective in this area. And what happens is charges go to the EEOC, they get stuck. In the meanwhile, somebody's languishing in the workplace or fired because they complained about discrimination or harassment in the workplace, and they're not getting a remedy because it's hung up on somebody's desk with a stack of files and nothing is getting done. Also, the EEOC brings very, very few lawsuits, at least the Atlanta District Office does, based on these kinds of claims. This statute skips that administrative step and allows an aggrieved woman, man, whomever, who's being harassed or subjected to workplace harassment to get legal relief immediately. They may even get injunctive relief to stop whatever's going on in the workplace. They don't have to wait for a federal agency to decide whether or not they have the time to look at the claim. I filed charge after charge at the EEOC, and then they sit. And when we call and say, what's going on? They say, well, it hasn't even been assigned yet. That's just unacceptable. And when somebody is being harassed in the workplace, it's dangerous. It's dangerous for that individual. This takes care of that. The other thing that many, many folks don't recognize, when we hear it in these cases, well, why didn't you call the police? Why didn't you do this? Why didn't you do that? Based on my experience in representing women in the workplace, time and time and time again, women are reluctant to come forward. They're frightened. They're one of the areas of problem areas in our practice is women getting blamed for the harassment. It's her fault. She was wearing something that was provocative, or I think, she laughed when I made that remark, what have you. Of course, people laugh all the time as a defense mechanism, but you have a 3-year statute of limitations in here. It often takes time for a victim of harassment, and in particular of sexual harassment, to get up the courage to come forward. And that time is necessary. When you have a 180-day timeline, which the EEOC has, if you don't file a charge within 180 days, you are out of luck. That timeline is not adequate, and it's not adequate to protect victims of sexual harassment in the workplace. So I think that this bill will go a long way towards protecting victims in the workplace. And the other thing it's going to do for the business side of things, it's going to put employers on notice of what their duties are. And that's a good thing, because what happens if the employer just doesn't educate their management and their HR about this? Well, what happens is they get claims, they get lawsuits, they get that kind of stuff. That can be avoided with this bill. So I want to address the concern about, well, what about if it's harassment outside of the workplace? I'd like to give a few examples of harassment outside of the workplace that affects the terms and conditions of employment. Let's say the supervisor, I have this case right now, supervisor at night texting the subordinate employee, hey, I'm over at a hotel. Would you like to come over? I'm over at such and such. Hey, would you like to come over to my house? Or, hey, can you send me some pictures of your fill in the blank? I'll send you a picture of my fill in the blank. That is harassment outside of the workplace by somebody that victim is going to have to see in the workplace the next day. Do you think that affects the terms and conditions of her employment? It absolutely does. She's going to walk in and see that supervisor and be intimidated, want to engage in avoidance. And when that supervisor comes into her office to give her instructions about what she's supposed to do and her job, she's not even going to want to look him in the eye, much less listen to what he has to say. And she's not going to know whether he's going to come into her office and talk about work-related issues or some kind of sexual thing. I've seen every kind of variety of sexual harassment, and both by supervisors and non-supervisors. It can start with a conversation about work and quickly turn to other things. One public employer talked about himself in the first person. I'll call him John Doe. for purposes of this hearing. He talked to his employees, and this was in a law office. You want to talk to John Doe before 5 or John Doe after 5? Okay. John Doe after 5 wanted to talk about and do things that would clearly constitute sexual harassment. Do you think that the women who were being confronted with this were uncomfortable and that this affected the terms and conditions of their employment? It absolutely did. It absolutely did. So I think that this bill addresses those concerns. Going to House Bill 1390, this one deals with county or city employers. We spend a great deal of our practice involved with county and city employers. And I'll give you a present day example. As recently as day before yesterday, front page of the AJC, we represent Captain Tanya Giovanni at the Lawrenceville Police Department, who has been a victim of sexual harassment in the workplace by a captain who was a coworker and by her chief. And she had the temerity to complain about it. Okay. Well, since that time, her job has been hell. And the retaliation has been both straightforward and subtle. Upon complaining to the city manager immediately, instead of launching an independent investigation, went to the very people accused of sexual harassment and told them about it so that they could react to her. And so one of them could stick a statement in front of her and force her to sign it, saying that he was not culpable. Okay. Beyond that, she's been cut out of the loop in internal communications in the workplace. And that is affecting her ability to do her job. Now, this is a 16-year member of the force who's risen to the level of captain. She actually supervises more officer than the other 2 captains in the department. And yet she's having to put up with this. This bill, 1390, addresses her concerns, or would address her concerns if it were the law today, and provides for a remedy if she is retaliated against in the workplace. Now, again, let's take that police department. We can take that police department. We can take any municipal or county department that's infected by managers, officers who believe that it's their right to make obscene comments to women, to ask them to send them pictures of their breasts, to suggest that sex with them would be better than sex with their husbands. This bill addresses that situation and allows a woman who's being subjected to that kind of conduct to feel that she has a remedy, that she can report it and be protected from retaliation. Okay. That's what that does. And it's something that the state of Georgia needs. I hear it time and time again, and I've heard it since I was a boy growing up, that Georgia wants to attract business. And we do. We want to attract business, and we want to attract people to this state who are highly competent in what they do. We have represented women and minorities and older workers in every walk in life. We've represented nurses, steel workers, school teachers. We've represented CEOs. We've represented executives. And it's a funny thing about sexual harassment. It affects them all the same way. And it's a funny thing about any kind of harassment based on a protected characteristic is so demoralizing. The most highly trained, highly educated executive can be brought to her knees by this kind of conduct. It keeps them awake at night. It affects their marriages. It affects their morale, and it runs them out of the company. And it can run them out of the state. And these companies need these folks. They're insightful, they're thoughtful. Many of them are brilliant. And it's a waste of human capital in this state to not protect these folks in the workplace. I'm going to go to the other end. Entry-level workers. They are the foundation of every business. And without them, the wheels of commerce in those businesses can come grinding to a halt. I have a case right now involving racial harassment in a warehouse at a large national company here in Georgia. And that warehouse is chaos. And a representative manager there who's being harassed by other managers, by other employees based on his race. And it's driving him out of the workplace. That shouldn't happen. What should happen is competent people should be able to hold their jobs and work competently and unmolested. So that's, in any event, I guess that's my opening statement. But I can't stress it enough. This is a bill whose time has come. In fact, this is a bill whose time has passed. It should be passed. It should have been passed long ago. And if we want to be a business leader in the state of Georgia, then this is a bill, both 1389 and 1390, both of them. I strongly recommend that our fine legislators pass these bills.
Mr. Buckley, I think we've heard quite a bit today about 1389 and the process that would be followed in the federal system, the EEOC.
Right.
I'm just curious about 1390. What obstacles are there currently for, appears here we're talking about retaliation based upon a complaint that's made for an existing local government employee to make those reports or to seek relief?
The present obstacles before these bills are passed?
Yes, sir.
Well, people work in government often because of the benefits, which are substantial, and I'll include their pensions in that. The pension can often be literally the tail that wags the dog in any kind of employee concern. I'm 5 years from retirement. I just want to get to retirement because then I'll get, enough to live on for the rest of my life. But if I quit now, I will lose half or 2/3 of my retirement. So there's a psychological barrier there. Right now, the officer I'm representing is 4 years away from retirement and would lose a whole bunch of retirement pay were she to just flee the workplace. Being able to report sexual harassment in the workplace without fear of retaliation and knowing that you have a right of action for retaliation should that occur empowers employees to come forward. And when they come forward, it is a powerful thing that can change the culture of the workplace. If the culture is a good old boy system, it can change that culture. City council members, county council members who may not know what's going on suddenly become alerted to the situation. They may need to change the city manager in order to change that culture, or change the department head in order to change that culture. So that's they call them the golden handcuffs. I can't leave because if I do, I'll lose so much. That's a big barrier. In the current system, that individual would have to file a charge of discrimination at the EEOC, would have to sit and wait. The mere fact of reporting it does not give them an immediate remedy should they experience retaliation. So, I mean, I have, I don't know how many days, weeks, months I've spent counseling people who are afraid of retaliation because they know that the employer has no real fear of any consequence for that. Does that answer your question?
It does. Yeah, we have a few other questions.
Okay.
Representative Smith.
Thank you, Mr. Chairman. Appreciate you being here with us today, and thank you for all the work that you do. I was going to go back. You had mentioned Justice Gorsuch in that opinion. It was interesting. A lot of us that are strict constructionists, we consider him to having shanked it pretty badly in that.
But he's a strict constructionist.
And then you look at who he clerked for, Justice Kennedy, and it's well, that makes sense. And basically, in his opinion, in a strict constructionist view, he read into that title something that the authors would Title VII they would not have contemplated at the time that they wrote this. So I guess I'm going to really dig into the absurdity of this pronoun business. What if somebody consistently uses the wrong pronouns for a person in the workplace? Because I can tell you, I am not going to call anyone other than ma'am or sir.
Right.
I'm not going to deviate from that whatsoever. So is there not a scenario as this is written with a gender identity language that if you consistently have somebody in the workplace using those pronouns that somebody doesn't prefer for themselves, would that not cause a claim of action here?
I think it may depend on the individual, and it may depend on how that pronoun is used, and the use of that pronoun once. I mean, I've made that mistake. I think any number of people have made that mistake. We had a vendor come into our office, and it was a man who had undergone sex change operation. And my partner came into my office and said, I want you to meet so-and-so. She will be doing some work for us. And the way he said she, I went, okay, whatever. Well, I went down the hall, met this individual who happened to be very talented in what she did. And it's very clear by the way she was dressed that she wanted to be a she. That's what she wanted to be. And she'd actually gone to the effort to have surgery in order to do that. I believe strongly in respect for the individual. I think that if somebody insisted on calling somebody that clearly identified in a particular gender by the other pronoun, that's not a religious issue. That's just, you're just kind of poking them in the eye with a hot stick. And I think that could be discrimination, or it could be harassment. On the other hand, the human mistake is another thing entirely. Yes, ma'am. Yes, sir. Oh, sorry. Got it wrong. I'll try to do better. I think that's, another issue. And I don't think that's workplace harassment, because you got to remember, workplace harassment is something that's intentional. I want to address your other issue about the form, a medical form or something that gets filled out, male, female, somebody is checking one box or the other. It's a form by your insurance carrier or something like that. I don't think that kind of incident is going to rise to the level of workplace harassment. Harassment needs to be severe or pervasive. If somebody's constantly taunting somebody because of their gender identity, I think that could rise to the level of harassment, workplace harassment. If somebody slips and calls somebody she instead of he, or the other way around, I just don't think that is an instance of workplace harassment. It's not severe and it's not pervasive. Does that answer your question?
It does. I'll just point out, though, that there are religious beliefs that would say that you go back to Genesis and that God created male and female. And there are religious beliefs, especially in the Christian world, sound theology tells you that as a Christian, you are to refer to someone as the gender they were at the time of their birth. And that no matter what surgery or what you decide that day you want to be called, as a belief of a Christian, you are in compliance with your faith required to refer to them as their gender at birth.
Well, I'm a Christian and I'm not familiar with that particular passage in the Bible, but
Right. It takes a little bit of theological understanding and reading the Bible
Right.
throughout, but you look at Genesis, that is the basis
right,
for that.
right.
And so sound theology would tell you that God created male and female. And so a person with that religious belief, that would, to me, they would not be able to refer to them to whatever pronoun they want to now be called.
I don't purport to be a theologian, and so I can't opine on whether or not somebody insisting on calling somebody by a particular pronoun when they have expressed a preference that they be referred to by another would be a religious act. But more than that, I can't state right now that telling somebody, well, you can't do that. If she wants to be called she, call her she. If they're saying, well, you're interfering with my deeply held religious beliefs. As you know, this statute, Title VII as well, protects people based on their religion. So it is possible, I suppose, for there to be times when there may be a clash between one's religious beliefs and some of these other protected characteristics. I'm not going to say it'll never happen or it could never happen. I think those instances are going to be rare. When they occur, of course, it appears to me both parties could have possibly a remedy, and that would have to be worked out in the courts. Am I prepared to come down and say, well, the religious person would win versus the person with the gender identity issue? I can't. I don't know. It would be up to a judge, and then it might be up to an appellate judge to make that determination.
Thank you.
Sure.
Representative Evans. Oh, Representative Gunner.
Thank you, Mr. Chairman. And I want to start out by saying I apologize for being late. So these questions might plow some ground that we've already covered. First of all, we've got two bills that create the same code section, but do different things.
Yes.
So is there a way to combine these two? And I don't know if you're the person to ask about that or not.
Yeah, I mean, personally, I don't know why they couldn't be. The only reason, and I'm not a legislator, the only reason why they may be separate, it may be that there's particular legislative support for one and not the other. I don't know that, but I don't really know why you couldn't tack on or incorporate the language and the distinctions in 1390 into 1389. If I were to do that, that's the way I would do it.
Well,
Yeah.
Yeah, the sponsor may.
Yeah, I wanted to add, and this is honestly and very candidly, this is my 5th session serving in the minority party in the Georgia House, and I have come to believe very strongly in a belts and suspenders approach to legislation.
okay.
I would love to have these together in one bill.
I think the question as to the same code section, that's always ironed out in the code revision bill, and legislative council addresses that.
Right. But the only difference in these two bills is lines in 1390, lines 26 through 33. Everything else is word for word.
Well, if I could jump in, Mr. Buckley, the question earlier was about the title where this bill proposes to put this language and whether it'd be more appropriate in the torts title. Do you have an opinion as to that?
Well, Georgia has been legislatively a little bit of a patchwork in terms of various legislation that protects workers versus legislation that is broader. The tort section, for example, a battery can be inside, outside of the workplace, can be anywhere, for example. I do think it would be, it would make sense for this legislation. In fact, it says that it's amending Chapter 5 of Title 34, which deals with women's right to equal pay. It would make sense to keep it in that section. You also have the Georgia Whistleblower Protection Act, which is a whole separate statute. In my mind, if the state legislature wanted to do a totally comprehensive job on this, they would put all of these statutes that protect employees in the workplace in one location where they'd be, all the easier to find. And I'm not just talking about for lawyers like me, but for regular walking around folks to want to know whether Georgia provides protection for employees in the workplace.
All right, Representative Gunner, other questions? Yes, sir.
One follow-up question. You stated that this kind of conduct would have to be severe and pervasive to trigger an action. Is that right?
Well, that is actually language taken from some of the case law concerning Title VII. I think that if you look at this bill, it doesn't say severe or pervasive. What it does is it talks about, and I'm looking at line 71 on down, it defines or seeks to define conduct that could constitute workplace harassment. And I think a fair reading of the language is it's saying one of these things could be enough in a given set of circumstances, or you could look at the totality of the circumstances. When I say severe or pervasive, and I think probably most people on this panel would agree, the sexual assault in the workplace would be severe all by itself and would constitute under this bill sexual harassment. It would constitute other things too, including perhaps a crime and assault and battery. On the other hand, the slow drip, drip, drip of sexual comments, or let's say one joke at the proverbial water cooler, might not be enough. Hey, I saw something on Netflix last night where these people were doing this and that, and it's something sexual, and somebody overhears it. Is that going to be enough to constitute sexual harassment under this bill? I kind of doubt it. I think it would have to be more of a continuous thing. People that have pornography up on their computer screens, the employee that walks in and there's her manager with, porn up on the screen, and that happens once or more than once, and depending on what he does or says about it when she's in the room. It might not be enough. On the other hand, it could be severe. If he's saying, wouldn't you like to do this? That could be severe. So it's going to be, and I think the statute is intentionally written so that the courts will be able to look at these on a case-by-case basis, and in a fair interpretation of the statute, make a call. Is this sexual harassment, or is this something less than sexual harassment? Does that answer your question?
I think so, but is there a reliance on case law to help define this so that
it's well, the statute's new, so there's no case law yet
on this statute, but in this subject matter, is there any case law in Georgia? Or
the only case law in Georgia, there are a few cases in Georgia involving instances of sexual harassment that involve Georgia law, and those are cases that involve assault, battery, intentional infliction of emotional distress. As you can imagine, a supervisor cornering a woman and making a whole bunch of sexual overtures, or telling her that her job depends on sexual favors, could be intentional infliction of emotional distress. There's also a little bit of law on the negligent employer, and I'm sure you've heard of negligent entrustment or negligent hiring. When an employer, and it's in this statute too, knew or should have known that an employee, say a supervisor, has a propensity for sexual harassment and fails to take steps to protect employees in the workplace, then that employer can be liable under garden variety negligence law. I believe the standard, however, for negligent entrustment, the burden of proof is a little higher than just the preponderance of the evidence. But it's there. Is it comprehensive, and does it cover this? No, it's a little bit of the appellate courts. I don't want to say chewing gum and baling wire approach, but I just said it. But they kind of take the cases as they come. And so there's this little patchwork of case law in Georgia, tort law, that covers this. And going back to your question, Mr. Chairman, this bill would not, in my mind at least, eliminate potential tort claims as well, but it is a comprehensive approach that specifically addresses the workplace, which is just really badly needed. The other tort law doesn't talk about the workplace. It's just assault and battery. Negligent retention, that's the one where truck drivers that have a bunch of DUIs and the employer knows about it, then they've negligently retained that employee, but it's not the law, and that's case law. That law is not fashioned specifically for the workplace. Does that help answer your question?
Yeah, this is way out of my wheelhouse.
Okay.
So that's why I'm asking.
Sure.
Thank you.
All right, a few other questions, Mr. Buckley, for Representative Dreyer.
Yes, sir.
Thank you, Mr. Chair. And I'll try to be fairly brief on this. On the negligence, the reason it's different in a workplace is because if I am negligence towards a stranger, there would be a justifiably a slightly lower standard than an interaction between specifically a supervisor
Right.
and an employee. Is that right?
Yes, I believe so. The employer does have certain duties to protect the employee in the workplace that go beyond your duty to protect the stranger as you're walking down the street.
That's right. That's why a special statute be needed. And I just want to tease out one thing you said at the end of the conversation with Representative Smith. You said you didn't know which side might prevail, but it's not just a claim that somebody who's non-binary might have. It's also a claim that a Christian might have as well under this law. Is that correct?
Religious discrimination exists.
Right.
And I have represented many people in religious discrimination claims. And so in a given circumstance, if a person believes that they're being discriminated in the workplace because of their deeply held religious beliefs, then they may have, this statute may give them access to a remedy. And I'll go a little further. If a person is being harassed because of their religious beliefs, then this statute would provide them a remedy. I'm going to take a really extreme view here, which I've actually seen. As you know, this country right now, we've got a problem with white nationalism. Some argue that that's actually a religious tenet. Okay. And so if a person takes to harassing somebody because of race in the workplace, basically expressing that this is, my religious belief or worse to that effect, and that person is disciplined because they're harassing a person because of their race, they can make a claim, I suppose. I don't know that the claim would be successful, but at the same time, the person who's being harassed because of their race would also have a legal claim. I do not know, because I'm not a judge at this point, how that would shake out. There have been cases in our country on the federal side where those issues have come up. You know, it's a case involving a company that because of the religious beliefs of the owners, they didn't want to provide contraceptives to employees. The case went to the Supreme Court. The owners prevailed. There are cases where people have expressed a religious abhorrence or other things in the workplace, and they've been litigated. I mean, I'm not going to say that litigation won't happen, or there may not be a clash of perspectives because of this bill. It can happen. I don't think that's going to be the rule. I think it's probably going to be the exception. I don't think you'll see much of that, but I don't, my crystal ball is cloudy as to whether that could ever happen.
That's right. Mr. Chair, can I do one final?
Yes.
But I just wanted to point out, religion is a protected class. Someone under this bill, that someone could bring a claim for. And finally, do you think that Justice Gorsuch shanked it, or do you think petitioner's counsel was incredibly compelling in that Supreme Court decision?
I think our
Thank you, Chair.
briefing is excellent. And again, I'll give credit where it's due to the lawyers that did it, Brian Sutherland and Thomas Mew. But Justice Gorsuch is a textualist. Okay. And he looked at the text of the statute. And by the way, it wasn't just Justice Gorsuch. He had company because he had a majority of the court, but he wrote the opinion. He looked at the text of the statute. And, I was present at oral argument, and he said, well, just look at the statute. Sexual orientation discrimination is sex discrimination. It's discrimination based on sex. And so he drew that conclusion. And I don't think he shanked it. I do think that, and this is the discrimination based on sexual orientation, is discrimination based on sex, and that he got it right.
All right, Representative Leverett.
Good morning.
Morning.
I would have the same comment for you, sir. Your stamina is impressive. I appreciate you.
And she's a much younger person than I am.
Well, I wasn't going to say that,
But
that,
I just did.
that does make your performance all the more impressive, frankly. Being a member of the same protected class you are. I noticed in the bill, we also do include disability and age down
Yes.
in lines 38 and 39. So this, I'm assuming this would include those characteristics as well as sexual harassment or things based on more conventional sexual harassment claims. What we think.
Yeah, yes, and it's even the federal law is a patchwork, a bit of a patchwork, because you have Title VII, which protects people based on race, sex, national origin, color, which is different from race a little bit, and then religion. Then you have the Age Discrimination in Employment Act, which has some different remedies. It's a whole separate statute unto itself. Both of those fall under the umbrella of the EEOC, and also the Americans with Disabilities Act is amended, falls under that same umbrella, but it's a wholly separate statute. What this bill does, it really does a better job than the federal government does in bringing all of these protected characteristics under the umbrella of a single statute. And it eliminates the administrative step that is so cumbersome and frankly ineffective.
Because right now you've got to, if you have one of these types of claims, you have to go to the EEOC, file a complaint, and wait until the results of their investigation. You get the so-called right to sue letter. Is that still the?
Correct.
And so you've got to go to the EOC within 180 days of the occurrence that constituted the discriminatory act.
That's correct.
So that does seem like a bit of a tight, effectively, a statute of limitations effectively.
And there are instances where an employee, they get discharged. They think maybe it's because of their age, but they don't really know. And then the employer, being clever, waits 180 days to replace that employee, or waits 181 days to replace that employee. So then the employee files a charge, and then they got to litigate whether they're too late or not. It makes the system cumbersome.
And we have a similar administrative agency or body within state law. I think they were here just the other day, I think before this committee.
Georgia Commission on Equal Opportunity.
Yes.
Yeah.
But this bill would not propose to preserve that same structure. You would have the right to go into court at any time. You don't have to go through an administrative proceeding before that.
You would not. I mean, I think with state employees, the administrative procedure is still there with the GCEO. At least the way this is drafted right now, I would not see that as an ongoing necessity.
For a private employee, if you have a claim against a private employer.
If you have a claim against a private employer.
And I didn't know that about the state. If it's against the state, you would still do that. So thank you for clarifying that.
There's no remedies under Georgia law that mean anything. Even Chapter 5, Title 34, the remedies are wholly inadequate. $100 fine, for discriminating based on pay is not a real remedy.
Yes.
Yeah.
That's all I have, Mr. Chairman. Thank you, sir.
All right.
All right. Those are all the questions. Thank you so
Great.
much. Mr.
Thank you
Buckley,
very
for
much.
being here
I
today.
appreciate your time and hope that you all will move these bills forward and get them passed.
Thank you. So we always give the sponsor the last word. Representative Nolowitz, I'll recognize you for any final. I'm sorry, you know what? There were some other people who wanted to speak. GMA and ACCG, are y'all available? If you can hear my voice, hi. Yes, ma'am. If you'd like to come forward. And this would be about House Bill 1390, right?
Hello, I'm Emily Hurst. I'm Assistant General Counsel with GMA. Thank you for the opportunity to speak today. We just had a very brief note just to say that we understand the need for employees to have protection from retaliation in circumstances such as these when they report potential sexual or workplace harassment. And we plan to work collaboratively with Representative Nolowitz and the committee to perfect the legislation.
Wonderful. Thank you so much. All right.
Thanks.
I don't see any questions. Thank you. All right. Anyone else? Yes, ma'am. If you'd like to come forward.
Good morning. I'm Megan Martin, appearing on behalf of ACCG. I'm glad to be here today as both a woman and on behalf of ACCG. Just as GMA have said, we think this is something that is needed, and we've really enjoyed being a part of providing some of the revisions to the sponsor that is handling this bill. And we would encourage you to take a look. We did provide some edits, I believe, this morning for our sponsor. And we thoroughly think that 1390 is something that we can support. So
Thank you so much. Thank you for being here. Don't see any questions. All right, very good. So we will now recognize Representative Nolowitz. Any final comments that you'd like to give?
I want to thank everyone for their stamina. I'm very grateful that we have been able to have such a thorough and thoughtful and candid and really respectful conversation here today. I am so grateful for all of the witnesses who were able to bring time and move forward and to help us move forward with this and to be able to bring their perspective to this legislation. I am so grateful for the questions and the insight that we have gained from, again, having this discussion with the committee today. I'm going to peek over so I can make sure I see everybody. But no, I'm grateful to have had this opportunity for this hearing. I don't think I can emphasize enough, and everyone has said this and said it better than I can, how needed how needed legislation like this is in Georgia. Again, would I love to have one omnibus bill that moves through? Absolutely. But I think that, knowing where we are in the session, I just think it's good that we have two that we can work with. And I'm so grateful for, again, the efforts of everyone involved in this, the continued work to perfect these bills to make them even better as we move them forward. I'm grateful and I am thankful to all of you. And I hope that you won't hesitate to find me on the floor or call or email me if you have any other questions about this legislation.
All right. Well, thank you everyone for your time today, and we are adjourned.